morning, everyone. This is Dr. Sumit Pahwa, your host for the webinar. And welcome all to the webinar on mandatory dematerialization of shares. Brief introduction about myself. I'm Dr. Sumit Pahwa, corporate lawyer and company secretary with 25 years of experience in legal and compliance domains. Currently, I'm the co-founder and CEO of COMPLINITY, which is India's leading compliance software, helping companies comply with the laws of the country. COMPLINITY covers 2,200 plus laws and a checklist of over 35,000 plus compliances updated on a daily basis. COMPLINITY is adding value to 1,000 plus companies in India, over 10,000 users spread across 75 plus industry verticals, from organizations like Panasonic, Max Hospital, Oberoi Hotels, Toyota, Yes Bank, British Council, Amazon's Battery, and many more. I'll request my team to very quickly share a 1 minute video on COMPLINITY, and then we jump onto the web.
Welcome to COMPLINITY Technologies. COMPLINITY is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. COMPLINITY is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose COMPLINITY every time. Join the most innovative and prestigious brands that use COMPLINITY. Automating your compliance management. Request a demo at complinity.com.
Right. Now, here are some of the links that are for everyone. So, for receiving a recording of this webinar and many other resources, follow us on social media. So, these are all the links of COMPLINITY social media. You can follow us on your on whatever you like. You get not only many more resources, video, articles, blogs, legal updates, etc., etc. And anyone who wishes to have a demo of COMPLINITY for their organization, please feel free to put it in the chat box to host and panelists, and my team will pick it up and reach out to you. Thank you. Okay, so now do we have the speakers here? Ms. Preeti Pahwa and Mr. Chandan Naran.
Yeah, hi Sumit, we are here.
Yes. Chandan, you're on mute, looks like.
Hi Sumit.
Yes. Hi, Chandan and Preeti. Okay, so before I offer your introduction, I'll give a brief background of why we are here. What is it that audience can expect today? Introduce the speakers and give it all to the speakers. So dematerialization, as we all know, is a process of converting physical securities into digital or electronic form. And while the provisions were already there for listed companies, and they were also there for unlisted public companies since October 2018, with certain exemptions, of course. The MCA very recently, not very recently, but a few months back, white companies, prospectus and allotment of security amendment rules 2023 dated 27th October 23 has introduced mandatory dematerialization of shares for securities, actually, for private companies, excluding small and government companies. So it's a big step, I would say. All the private companies, there are more than 14 lakh companies in India, and more than 90-95% would be private companies. So the private companies are now coming under the umbrella of dematerialization with effect from 30th September 2024, which is 18 months of the close of the last financial year, which has now therefore led to an urgency among the stakeholders to get a deeper understanding on the subject, procedure, and the compliances involved. And that's why June, July, August, September, 4 months are left. If you are already dematerialized, very good. If your company has not created their ICSI and your shares are not dematerialized, it is high time that the shares should be dematerialized. And of course, the practicing side may advise their clients to get their shares dematerialized, and that's the currency and the relevance of the subject. What you can expect in today's webinar is, of course, key definitions to start with. Sometimes even the basics. It is very important for us to brush up and be aware of the terms, terminologies, etc. Then we'll touch upon legal provisions about mandatory dematerialization. We'll get into procedures, compliances, etc. And a lot of FAQs, some frequently asked questions which have been asked to us by our clients or generally which are there, and gray areas as much as we can comment about them or at the least pose the question. And of course, there will be audience Q&A. Now, to the audience, just like all other webinars, if you have any Q&A, keep putting it in the Q&A box. I'm the moderator, and here we have the speakers. Now, introducing our first speaker, Ms. Preeti Pahwa, and I'll just share my screen and introduce. 1 second. Yes. So here we have Ms. Preeti Pahwa, a fellow company secretary and a corporate lawyer with 25 years of experience. Preeti has considerable expertise and rich hands-on experience in corporate secretarial and board matters under Companies Act, Secretarial Standards, and FEMA. Preeti is supported by a strong team of company secretaries and lawyers at eMinds Legal, which renders secretarial and legal services to several small, medium, and large Indian and multinational clients. Other than that, Preeti is also an expert on Posh. Preeti has handled several investigations, conducted several workshops. She's an active member of the task force on Posh constituted by ICSI, and she's been playing a vital role by sharing her views and rich experience on the development and editorial of Corporate Law Referencer, which is a leading book on company law. And the next speaker is Mr. Chandan Naran. He's an Preeti, I forgot to mention, she's a partner at eMinds Legal, founder partner at eMinds Legal. Chandan Naran is an associate partner at eMinds Legal. He's a fellow company secretary, corporate lawyer, over 17 years of experience, specializing in corporate secretarial, governance, FEMA, securities laws. He has extensive experience in debt and equity financing, transactions, investor agreements, deposits, buybacks, mergers, winding up due diligence, etc. The whole 9 yards of secretarial, I would say. At eMinds Legal, Chandan leads the secretarial vertical, overseeing a team of 30 professionals, and he's been instrumental in shaping the editorial content of Corporate Law Referencer. So welcome Preeti and Chandan, and thank you for being the speakers on this forum.
Thank you so much, Sumit, for the introduction. Thank you. And
Thank you for having us.
hello, everyone, all the attendees, for sparing your valuable time to attend a webinar on this important topic, the need of the hour to understand the dematerialization and the legalities and the procedure behind it.
Perfect. So over to you, Preeti, without wasting any more time, over to you to start the presentation.
Yeah, 1 second. Let me just share my screen.
And by the way, while Preeti is sharing her screen, there's a surprise towards the end of the webinar. There's a surprise at 1 o'clock. Let me see that. And it's a very, very important surprise, very important event, and it's going to be the first time happening on this webinar or on our webinars. So just look for that. Okay. Over to you, Preeti.
All right, give me a second. Let me just adjust my screen.
Yeah, and since I gave those extra minutes for people to join in, from that time till now, 100 more people have joined in, in those 5-7 minutes, so I think that's worth it. Yes, over to you, Preeti. The screen is perfectly all right.
All right. So, hello, everyone. For those who just joined, I'm Preeti Pahwa, partner eMinds Legal, and I'll be today talking about the legislative content or the legal provisions on dematerialization of securities, which is mandatory now. Basic things first. On the first slide, you can see all of us would know what do we mean by dematerialization. It means it's a process of converting physical security certificates into an electronic form, e-form. So the share certificates, the physical form, get converted into a dematerialized forms. There is nothing that you can see or feel or touch, but still the shares exist. Behind every act of the government, there is a basic or a short history, something that leads to what has led to the dematerialization of securities today of private limited company shares. Starting with 1996, the Depositories Act was introduced, which introduced the concept of demat of shares. Jumping to year 2000, where this Companies Amendment Act of 2000 made mandatory dematerialization on IPOs worth rupees 10 crore or more. Then in the year 2013, the new Companies Act 2013, the section 29, which talked about public offer of securities to be in demat form, made it mandatorily applicable on every company making public offer. It was made applicable on every public company, and it also talked about some prescribed class of public companies. Although the class wasn't prescribed in the year 2013, in the year 2018, like I said, it wasn't a new concept, but by the company's prospectus and allotment of securities, Third Amendment Rules 2018, the issuance of securities by all public unlisted companies in demat form was made mandatory. So the rule 9A, which was made effective from 2nd October 2018, came into existence. Then came the year 2019, very important, where through Companies Amendment Act of 2019, the word public, which was used in the such other prescribed class of public companies, we've mentioned it in red above in the year 2013 Act. The word public was removed. So effectively, it was applicable on every company making public offer and such other prescribed class of companies then. Now, coming to the current year, 2013, the latest amendment. In the year 2023, the law made it mandatorily applicable on private limited companies through insertion of Rule 9B. This was dated 27th of October. The intention or the idea behind this move was not only to improve the ease of doing business in India, but also to curb, something called as Benami transactions. There were a lot of litigations happening on issuance or transfers basis fake share transfer or share certificates, share transfer deeds. There were improper share pledges being made by use of fake share certificates. So I'm sure if the shares are demat form, these kind of malpractices will not going to be happening in the future. This will also, I'm sure, is going to ensure transparency, and also this will assist the government agencies to trace the shareholders of private limited companies. There's a problem that the shareholders are non-traceable. The shares are non-traceable. For example, in case of shareholder meeting, we need approvals from those shareholders, but we are unable to trace them. The shareholders or the companies do not pay adequate stamp duty on the issues of physical share certificates. So in case the shares are in demat form, these entire malpractices are going to end. In dematerialization, these are basically three pillars. One is depository. So who is a depository then? It's an organization which holds the securities of investors in electronic form. In India, there are two depositories only. One is NSDL, National Security Depository Limited, and the other one is CDSL. They also provide services related to transaction and securities. Second important agency is the RTA, Registrars and Share Transfer Agents. RTAs act as intermediaries between the issuers and the depository participants for providing services such as, demat of shares, rematerialization of shares, participating in IPOs. Various corporate actions are filed with RTAs, and they act on that. It's a SEBI registered entity which acts as, so RTAs are basically agents of the issuer. The company issuing the shares, they appoint RTAs as their agent. They verify the request received for demat from the depository participant and forwards it to the company. So basically, they act as agent of the issuer, and they act as intermediary between the issuer and the depository participants. And who are then the depository participants? Now, depository participants are basically the agents of the depository. So depository also acts through the participants. It interfaces with the investor and provides the depository services. So basically, now depository interfaces between the investors and the depository participant acts as the interface between the investor and the depository to provide the depository services. DP may be a public financial institution, a bank, a foreign bank operating in India with the permission of RBI. They can also act as a DP. State financial corporations, stockbrokers. There are various NBFCs and RTAs also who are complying with the regulations prescribed by SEBI, for registration as depository participant. So basically, there are three constituents, as I mentioned, for demat of securities. One is depository, RTA, and third is the DP. Very important now. Now, this is now what the most important part of the legislation. The company's prospectus in allotment of securities rule 2014. It mandated the issuance of securities in demat mode for all unlisted public companies via Rule 9A. As I mentioned in the brief history of or the emergence, Rule 9A was made mandatory with effect from 2nd October 2018. Rule 9A provided that the companies, the unlisted public companies, shall issue the securities in demat form and shall also facilitate the demat of all the existing securities. So this is applicable on unlisted public companies. The unlisted public companies also will have to ensure that before making any issue of securities or buyback of securities or issuance of bonus shares or any rights issue, the entire holding of promoters or the directors and KMPs have been converted into demat form. So therefore, the promoters, directors, and KMPs are mandatorily required to get their holding converted in demat form before such unlisted public company comes out with any further issue. So every holder of securities of such companies who intends to transfer such securities on or after 2nd October 18 or subscribe to such securities, it is mandatory for them to get their holdings dematerialized before either such transfer or further subscription to the shares. There are unlisted categories of unlisted public companies which are exempted under the rule. They are nidhi companies, government companies, and wholly owned subsidiary public companies. So, for example, an unlisted company which is a wholly owned subsidiary of any company, is exempted from basically compliance with this rule 9B. Coming to rule 9B now. Rule 9B is something which brought this entire hue and cry of getting the securities dematerialized, getting the ISIN created for them. Any ISIN which used to be created earlier in 15 to 20 days or maybe maximum 30 days time, it's getting time consuming now. We've applied for our clients for ISIN creation. It is almost 3 to 4 months now. However, it's because of the huge rush, for the obvious reason. So Rule 9B is being introduced in the company's prospectus and allotment of securities, Second Amendment rules of 2023. It governs the mandatory dematerialization of shares in private limited companies. And that's the difference. Rule 9A talked about unlisted public companies. Rule 9B talks about issuance of securities in demat form by private limited company. Okay. While most of the clauses or the important initial clauses of dematerialization of by public unlisted public company or by private companies are same, yet I would like to reiterate those 4 points. Issuance of securities in demat form. It is the responsibility of the private limited company to issue the securities in demat form and facilitate demat of all its existing securities. It has to ensure that before making any issue or buyback of securities or issuing bonus shares or rights offer, the entire holding of promoters, directors, and KMPs is in demat form. Again, similar as to unlisted public companies. Every holder of securities of a private limited company who intends to transfer or subscribe to this for the securities have to get all their securities in demat form before the transfer or the new issue, whichever, whatever the case may be. These categories of private limited companies are exempted. Small company, as we are aware, small company is a company with a paid up capital of rupees less than 4 crores and turnover of less than 40 crores, or a government company. So they are exempted under the rule. Very important now, the prescribed timelines. Law has prescribed 18 months. These are timelines for dematerialization of securities. 18 months from the closure of financial year of a private company, which is not a small company, as per audited financial statements. The period, starts. So they say that the period ends on or after 31st March 2023. For example, A private limited company is a small company on 31st March 2023, right? So it is not required to dematerialize its securities in the prescribed 18 months time. Moving ahead to the year 2024. So during 2023 and 2024, this financial year, assuming in December 23, it becomes a normal company. It doesn't remain a small company. Then this criteria will be checked on 31st March 2024, and it gets 18 months time from 2024. So therefore, 2024, 31st March 2024, audited balance sheet, if it says that it's not a small company, it gets 18 months time from 2024 to get its securities dematerialized. Okay, there are common compliances, very important compliances under Rule 9A and 9B. One is to obtain ISIN for each type of securities. The ISIN creation is not company specific, it is security specific. So if you have various classes of securities, categories of securities, you have to obtain ISIN for each type of security. Also, we have to ensure that the payment of fees to the depository is made on time, and there is a requirement to maintain security deposit of not less than 2 years fees with the depository and RTA. In the coming slides, we will also share a schedule of fees, which is currently prevalent. And the law says now that the companies will have to maintain a security deposit for not less than 2 years fees with depository and RTA. And the company has to comply with all applicable regulations or directions issued by depository or SEBI. Now, if a company defaults in in payment of fees, or in maintaining the security deposits, or in compliance with the regulations by depository or SEBI, it cannot offer any securities. It cannot go for buybacks. It cannot issue bonus shares or rights issue till the time the compliance or the non-compliance is made good. So either if it is defaulting in making payment of fees, it has to pay the fees, get an NOC from them, from depository and RTA, and then it can go ahead and come out with the issue. Also, the requirement now is to submit PAS 6, which was earlier applicable on public companies and unlisted public companies. Now it's applicable on private limited company also. PAS 6 has to be submitted with MC within 60 days from the conclusion of each half year. PAS 6 is a reconciliation of share capital audit report. It's a half yearly form that needs to be filed with the ROC. Grievances of the security holders. So the IEPF authority has been granted this authority to handle the grievances of security holders. Also, another thing, it is the responsibility of the company, in case there is any difference observed in the issued capital and the capital held in demat form. There are times when reconciliation gets done, there is a difference that is found between the issued capital and the capital held in demat form. It is the responsibility of the company to immediately bring it to the notice of depository so that the same can be corrected with. Also, the provisions of Depository Act of 1996 and SEBI Depository and Participant Regulations of 2018 and SEBI Registrars to the Issue and Share Transfer Agent Regulations. These are 3 important acts and regulations. These provisions shall also apply mutatis mutandis. So they will also be applicable. Coming to the penal provisions. Now, the sections or the rules have not provided any specific penalty, and therefore the general penalty under section 450 will be applicable in case of any non-compliance. The company shall be punishable with fine of rupees 10,000, or in case of continuing default, 1,000 per day. And the maximum limit of penalty is 2,000 or 2 lakh of rupees. And officer in default or such other person in default, again, the penalty remains the same, but the maximum penalty is limited to 50,000 rupees. So these were the basic provisions of dematerializations, which came out in Rule 9A, 9B. I would now request my associate partner Chandan to take the process and practical implications going forward. Let me just unshare the screens, and I would request all of you to keep noting your queries, and we can take that up in the Q&A FAQ Q&A session. Chandan, over to you.
Thank you, Preeti. Uh, Thank you for so meticulously elaborating on the legal provisions. I believe most of the queries with respect to its applicability, the timelines, etc., have already been cleared. Most of the people have queries with respect to the same. So now, since we know what are the legal provisions, it's time to see how do we go about that. Now, there is a requirement to have ISIN created and get your shares demat. But what is the process, and what are the practical implications to that? So, just a second. Yeah. So first of all, we'll talk about the process for obtaining ISIN, which is the primary purpose, primary objective. So you need to appoint your RTA first. That's the first step, because as Preeti mentioned, RTA works as an intermediary between the company and the depository. So you need to have your RTA appointed first. Once you appoint your RTA, you make an application to depository. So it's very important to note that the company cannot make direct application to depositories, CDSL or NSDL, whichever depository you choose. The application has to be moved through RTA only. Upon filing application to depository, the depository will review the application. Of course, RT will have the first level check. We'll go through the documents and confirm that. And once the application is moved to depository, the depository will review the application. And if the depository is fine with the application, we'll have to proceed with the payment of fees, the depository fees and the RTA fees. Once you make the fees, then the depository will allocate ISIN to the company. So this is a brief process. We'll now move to understand what is the documentation involved and all. So important documents for obtaining ISIN. So first is the RTA appointment letter, as I mentioned. So even before RTA appointment letter, you need to pass a board resolution before to select your RTA and to get your shares admitted into the depository with the depository NSDL or CDSL. So you will approach an RTA. RTA will send you an offer letter along with the format of their appointment letter. They'll cover various details about their appointment. In case you need to discuss anything with them, you can coordinate and get your things cleared. So that RTA appointment letter is therefore a very important part of your overall documentation. Another is the master creation form. This is the format which is given by the depositories, NSDL or CDSL. So CDSL has one form, NSDL has divided into two parts, Part A and Part B. So this form basically talks about the issuer details, the name of the company, registered office address, if there was any change, of name, etc. So details about the issuer and the details about the security for which you are going to obtain ISIN. So the entire history about the company and the security for which you are going to obtain ISIN. Third is the tri-party agreement. So this is the agreement between the company, RT, and the depository. So the guidelines, the terms and conditions, the action items, etc., are mentioned in the tri-party agreement. The roles and responsibilities, etc., are given in the tri-party agreement. Board resolution, as I mentioned, also needs to be given for appointment of RTA, and for the depository also would like to have a board resolution wherein the company has authorized the board to apply for emission of securities for obtaining ISIN. The standard documentation are like certificate of incorporation, MOA, GST number, annual report, etc. Details of shareholding is important because you need to give the security wise details, the shareholder wise details, the certificate number wise or distinctive number wise details. So a proper Excel has to be given. A net worth certificate has to be obtained from a practicing chartered accountant, which is one of the documents. And if there are these are the standard set of documents. Upon going through these documents, RTO depository might ask for any further documents for clarification or otherwise. So this is how you go about obtaining your ISIN. So once you have obtained ISIN, the other step is, before getting the shares converted, you need to have demat account. Every security holder needs to have a demat account to get its securities dematerialized. So for opening of Demat account, you need to first select your DP. DP is, as Preeti mentioned, DP is intermediary between the security holder and the depository. So DP can be any bank or NBFC or foreign bank having a license in India, etc. Preeti has clarified on that also. You need to select your DP. Just ensure while selecting your DP that your DP is linked to the same depository with whom the company has obtained ISIN. It should not be like that company has obtained ISIN from NSDL and your DP does not have an account with NSDL. It has an account with CDSL. So if that happens, you'll not be able to link your securities, with that DP. Once you select your DP, so then submission of documents for Demat account opening happens. We'll talk about the list of documents also, which are pretty common and mandatory for opening of Demat accounts. So once you submit the documents, then there is a mandatory KYC. So it's in the form of a CKYC also. You submit various documents like your proof of address, proof, your identity proof, your income proof, etc. So then mandatory KYC will be done. Once the KYC is okay, your documents will be verified by the DP and the Demat account will be opened. You'll get a BOID. BOID is beneficial owner identification number. So this is how you open a Demat account. The documentation required for opening of Demat account generally is like for individuals, there is a Demat account opening form which you need to fill and file. Your identity proof, your address proof, proof of income. So in case of NRI, you need to submit a passport copy also and one foreign address. FATCA declaration is also required and your latest bank statement. These are the standard set of documents required for DP for individuals. Basically, for body corporates, including Indian or overseas, the list is bigger. So again, some of the documents are common, like your Demat account opening form, the charter documents of the company, COI, MOA, AOA, PAN of the body corporate, the board resolution for opening of Demat account, proof of principal place of business, audited balance sheet, latest shareholding pattern, details and KYC of authorized signatories, who will be the authorized signatories to operate the Demat account, duly filled FATCA declaration and latest bank statements. So this is a common list of documents. Of course, while you submit your documents, your DPs might ask for further documents. For example, you don't have in your passport, you don't have your address mentioned, so you might be asked for a utility bill or government issued ID. So these kind of documents can further be asked.
Welcome to COMPLINITY Technologies. COMPLINITY is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. COMPLINITY is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose COMPLINITY every time. Join the most innovative and prestigious brands that use COMPLINITY. Automating your compliance management. Request a demo at complinity.com.
Now the ISIN is created, your Demat account is opened. Now that you have to convert your securities into Demat form. Opening of Demat account would not automatically convert your securities into Demat. You'll have to submit certain documents for conversion of your securities into Demat form. First is the security holder. So this is the process which is taken through the security holder, not through the company basically. So there is a Demat request form. So the security holder will submit a Demat request form to its DP. So this Demat request form will have informations with respect to the securities you are holding. With the DRF form, you need to provide the security certificates also with the DFA surrender for dematerialization, because you cannot have securities both in physical as well as Demat. So you have to get your share certificate surrendered, and then only you can apply for conversion into Demat. This DRF and authentication will be done by the DP. And before converting, now DP will have to link with the RTA. RTA is the authority from the company side. Depositories are the custodians. Now DP has come into picture now. So DP will go to the RTA of the company and request for crediting the shares into DP's account, and DP will further credit into the security holder account. So RTA will also verify okay with the physical share certificate, because RTA will have the entire. Remember, I talked about the shareholding details in Excel, which is filed at the time of creation of ISIN. So the security wise detail, the certificate number, distinctive number wise detail. So once the copy of this defaced share certificate is given to RTA, RTA will verify it its end and will give a go ahead. So generally, before giving a go ahead, RTA, at the back end gets a go ahead from the company's authorized signatory also, right? So any further document, if RTA is asking for any further documents, for example, to ensure that these are not the fake documents, for example, or any requirement which RTA feels or the DP feels, they may ask for further documents. No, but there are certain challenges why we convert securities into demat forms. So the list of documents, etc., I've talked about. But the challenges which we've also experienced in certain cases, so we want to highlight those. Just like holding of PAN is mandatory requirement even for foreign security holder. So generally, these days, as we are aware, for if your director is a foreign director, we need to have a PAN. If your security holder is not a director, right? It's simple security holder. For conversion of securities into demat, we need to have a PAN for that, individual or body corporate also. We need to have an active bank account in the native country for that foreign security holder. We experienced in one of the cases there is an entity which holds securities into Indian company, but that entity was not holding any bank account. It was not required in the native country. But for opening of demat account, that bank account is mandatory. KYC of foreign security holder to be duly apostilled and notarized. So this takes a lot of time. At times 3 to 4 weeks for notarization and apostillation. So that has to be built into your timelines. CKYC of directors or individual promoters is also required. So your body corporate is your security holder. So for the body corporate, we will submit various documents which we've talked about. Now for the directors or individual promoters also, we need to provide KYC documents and get their KYC cleared. At times, your foreign security holders are not comfortable sharing their personal details, the personal details of their directors, individuals, ID, address, etc. So this is a challenge, at times companies do face. Demat account of nominee shareholder is also required. You might say, okay, the beneficial holding is 100% beneficial holding is with with the holding company, but you have nominee shareholders also. So you need to have demat account of nominee shareholder also, because in the bank posts which will be shared by RTA and in the records, one share will be shown in the name of nominee shareholder. And if you select a DP, which is a bank in India, so you need to open a bank account also, which is mandatory. But if you open it with any other DP, which is not a bank, so you need not open. They'll not have basically a facility to get your bank account open. You whatever bank account you have, you can simply link that bank account with your Demat account. So we've categorized the fee structure, of the depositories, DPs, RTAs. The important, the major RTAs which are in the market. So just for the reference of everyone, this gives an idea about the cost involved. So first, with respect to depositories, there are only two depositories, CDSL and NSDL. Both of them has the same fee structure. The fee, it depends on your paid up capital. For example, up to 2.5 crores of your paid up capital, there is a 5,000 annual fees. For both NSDL and CDSL. 15,000 is your joining fees. If your paid up capital is beyond 20 crores, then 75,000 is your annual custody fees. That's all. For RTAs, we've listed down for 4 RTAs, which are important. 5 we've mentioned about CDSL and NSDL because they have their own branches also as RTA. CDSL Ventures Limited is an arm of CDSL, and NSDL Database is an arm of NSDL. So if you open if you select your RTA, CDSL or NSDL while selecting, which depository you want to go for, the process and the coordination gets a little smoother or easier. So, the annual maintenance fees for mostly all the RTAs is like 5,000 per annum. DPs, we mentioned about stock holding and other Orbis financials. Stock holding is pretty common these days amongst the body corporates. So they have a fee structure of, individuals is just 3,000, 15,000 per demat account for in body corporate, or foreign individuals, 50,000 for foreign body corporates. Orbis Financials is, we don't have any vested interest with Orbis Financials. Why we mention is because they are pretty open to opening demat accounts for the foreign body corporates, and the coordination has been, quite easier. Your, foreign body corporates might also ask, for example, if you have an account with JP Morgan or HDFC or any of the banks, they might say that you better go for, the demat account opening with those banks also only, and then you select your DPs accordingly. So now we'll talk about the benefits of having securities in demat form. Of course, there is a legal provision that we need to get our securities dematerialized. There is a mandatory requirement, and Preeti talked about the penal provisions also. But there are certain benefits which are there if we have our securities in demat form. There is an improved corporate governance. You don't need to maintain a lot of documents with respect to your shareholding. Your RTA is maintaining your records. You can simply get the bank post downloaded and see your shareholding. There's a lot of transparency and efficiency for the security holders also. They simply can log into your demat account and see their securities. Easy transfer and transmission. Transfer and transmission also happens through DPs. You have to submit a DIS, depository instruction slip, for transfer of shares. So you can simply transfer it, and the DPs will coordinate amongst themselves with the help of RTA, and then the shares will be transferred. Easy credit of corporate benefits. For example, the company comes up with a bonus issue, a right issue, the entitlement will be credited to your demat account then. It gets very easier. You don't need to have a separate documentation, no need to have separate issuance of share certificates, etc. So corporate benefits, including, if we talk about the dividend, so your demat account is linked with the bank account. So your dividend can directly be credited into your bank account in that case. So paperless, as we all know. So there are various stamp duty advantages also. For example, if you go with the issuance of securities, so you need to file proper stamp duty adjudication application to the revenue department. Here, you simply need to pay your stamp duty through NSDL or CDSL portal. If you are making a transfer, you need to procure share transfer stamps. Here, your DPs will ask you to pay the share transfer duty with respect to transfer. The added advantage is that if you are aware about Finance Act 2019, which came up with the reduced rate of stamp duty on the issuance as well as transfer of shares. Generally, the revenue departments have been till date seeking duty at the rate of 0.1%. However, the Finance Act talked about 0.005% for the issuance of securities. You see, almost 20 times stamp duty RTs are still asking. But if you have your shares in demat form and you pay your stamp duty through CDSL or NSDL portals, they'll calculate automatically, and you'll have to pay 0.005%. That's a huge benefit which companies having shares in demat form currently are having. With respect to transfer also, it used to be 0.25%. Now the Finance Act talked about 0.015%. So there is a lot of advantage on the stamp duty part when you have your securities in demat form also. I think I've covered the entire process, of how to obtain your ISIN, what all documents required, how to go about your demat account opening and conversion of your securities, the fee structure and the benefits. Uh, you know, uh, Now the legal provisions are we've talked about, the we've talked about. However, there are certain frequently asked questions or the gray areas you can say, or the points to ponder, which we experience on a regular basis. And you might have similar questions also. Maybe we'll simply pose a question. You can give your response in the chat box. We'll also let us know our view on that quickly. So the first question is whether a private company which is a wholly owned subsidiary of an unlisted public company, referred as deemed public company, is required to comply with the requirement of dematerialization. So I'll ask the audience if they have any view on that. Preeti, you're there?
Yes, Chandan, I'm here.
I guess we don't have any response. Sumit, do we have? Can we check if the audience is having any response?
Okay, 1 second. So, my team, Sanat, can you open the chat box? Yeah, give us a second. Let the chat box be open. The chat box is, I think, not available currently. Give us a second. Maybe you can answer this one. We'll have
Yeah.
the chat box available. Yeah.
So basically, if we talked about the exemptions, for the unlisted public companies, the exemptions cover only Nidhi companies, government companies, and wholly owned subsidiaries, which are unlisted public companies. In case of private companies, the exemption talks about the small company or the government company. Incidentally, a private company which is a wholly owned subsidiary of another private company, there is no exemption as such. While there is an exemption for unlisted public company which is a wholly owned subsidiary, so there is a perhaps they'll either clarify their picture that now unlisted public companies will also get into the radar. Now they have made it applicable on the normal private company also. So ideally, unlisted public company should also be now become be now required to have their securities into demat form.
Yeah, okay. So chat box is enabled now. So friends, please don't ask any question in the chat box. Question only in the Q&A box. But yes, this chat box is for the question that Chandan or Preeti will be asking you. It's a reverse webinar. You wouldn't have seen speakers asking questions to the audience. So just say yes, no, whatever your view is on the question on the screen. Okay, Chandan, go ahead.
Yeah. So next question is whether it is mandatory to alter articles of association of the company if it is silent on the provisions of dematerialization.
So
Yeah.
so people are answering yes, no, maybe. A lot of answers. Sumit, you're on mute. Sumit, you're on mute.
Yeah, I'm sorry. I was saying this is the energy of the room. This is the closest we can get to the audience, in a webinar format where at least there are so many people behind, and they are listening to you. They are offering their views. So yes, at the appropriate time, you may go ahead and answer the offer the correct answers. Yes, but yes, thank you, audience. It's quite good to see so a lot of energy and the answers. So keep going. Yeah.
Yeah. So as per our view, generally the articles of association of a normal private company talks about issuance of shares in in a physical mode, issuance of share certificate, distinctive numbers, and all. There is a express provision with respect to issuance in the physical mode. Now, as per our view, you should have a proper authority in your articles to issue shares in dematerialized form. So you should get your articles altered to have the provisions give authority to the board to obtain ISIN, and then with respect to transfers also that authority there should be there. So next is how will a private company restrict transfer of its securities? Will DPs ask for board approval before transfer? So generally, the context is the private companies can have the right to restrict transfer of shares. The shares are not generally and easily transferable in a private company. Now, once you have your shares in demat form, so the request for transfer of shares go from one DP to another DP, right? So the company generally does not get into picture, and this is how this gets applicable on the public companies, the listed companies also. How do we restrict the transfer of shares in case of private companies then? So I tell you, there are certain, there are DPs, there is no such express clause in the tri-party agreement or anywhere. But considering the requirement in private companies, DPs before transferring it will anyways have to go to RTA. And nowadays RTAs have started this, process to seek a confirmation at the back end from the authorized signatory of the company. However, RTAs might miss to get that approval, right? So there is a facility available with both the depositories to freeze and unfreeze your ISIN. If you freeze your ISIN, so the transfer will not happen in that ISIN. So in case you need to allow transfer, you can defreeze again. There is a cost involved for that, for freezing and unfreezing, but at least you are sure that none of your shareholders without your approval can simply transfer the shares. So next is whether a private company already having securities in Demat form is required to file PAS 6 for half year until 31st March 2024. This is a very common, very open question these days, considering the timelines for filing is today, 30th of May. So we are getting yes mostly for these questions, and our view is also that once you have your shares in Demat form, it's the while for transfer and for allotment, issuance, etc. It is mentioned that the due date by which the company is required to get its securities dematerialized. For PAS 6, it is not mentioned, but it's a simple form. You better go and file your form rather than avoiding any complications later on. Whether securities other than equity shares are also required to be dematerialized. Yes, securities other than equity shares, Preeti has covered in our slides also. Each type of security is required to be dematerialized. Now, for example, if you have equity as well as CCPS, two types of securities, but you issued CCPS on different dates and having different maturities also. For each separate maturity, your depository will consider it as a different class of security, right? Which means you need to obtain ISIN for each class of security. Each security having a different maturity allotment and maturity date, you need to obtain a different ISIN. What if a company has issued convertible securities with different maturity dates? I think I've covered this in my previous answer only, so let's skip this. Whether all security holders are required to convert their securities into dematerialized form. See, the law says by 30th of September, in case your company is a private company, which is not a small company, by 30th of September 2024, you need to facilitate dematerialization of shares. By facilitation, it means that you need to procure your ISIN so that your shareholders are able to dematerialize your securities. It's not mandatory for the shareholders to, mandatorily, convert their securities into dematerialized form. However, there are certain, requirements. For example, if your company is willing to, proceed with the right issue, bonus issue, buyback, any kind of offer your company is willing to give, then the promoters, directors, and KMPs shareholding should have been in dematerialized form. Additionally, in case you want to transfer your shares, you need to get your shares securities into dematerialized form first. Or in case you need to subscribe to any further securities of the company, you need to have your existing securities also into dematerialized form. Can electronic holdings be converted back into physical share certificates? Yes, there is no restriction to that. You just need to comply with what all I mentioned with respect to transfer and subscription of securities. Just like Preeti mentioned, the physical share certificate you can see, feel, and touch. At times there are shareholders who say, मेरे को मजा नहीं आ रहा basically, have to see it in a demat form. I want to have my physical share certificate also. You can place a demat request to get a new physical share certificate. But again, in case you need to transfer it later on, you need to again get that converted into demat.
And Chandan, on a lighter note, people who want to get the credit of, gifting physical share certificates to somebody, the beauty of gifting a physical share certificate is more than signing a DRF or a transfer form and just, electronically transferring something. So I've met somebody earlier, a few days back, and he wanted to get the shares converted into a physical format so that he can gift it to his daughters, and so that she can have the pleasure of having the share certificates as a gift.
But now, Preeti, since it is mandatory to have your share securities into demat, you need to get it converted into demat.
Yes, agreed.
Whether a private company can issue or transfer securities in physical form before 30th September 2024. Yes, if we go through the rule, which Preeti elaborated earlier also, it says in case you want to go for further offers, issuance, buyback, or the transfer, etc., has to happen, on or after the prescribed date by which the company is required to get its securities dematerialized. then you need to have your securities into demat form first, which means 30th September is the earliest date by which the companies are required to get their securities into demat form. In case you need to further issue or transfer your securities prior to 30th September, as per our view, you can do that. Whether a private company can issue securities in demat form after 30th September if all of its shareholders have not dematerialized their shares till date. See, the requirement is that for further issuance, buyback, etc., the promoters, directors, and KMPs are required to have their securities into demat form. And in case a shareholder or security holder has to invest further, subscribe to further to the issuances, then that security holder needs to have his or her securities into demat form, which means the other shareholders who are neither the promoter, directors, or KMP, or who are not subscribing to the new issuance, they can have their securities. They need not have their securities into demat form by 30th September. Even after 30th September, if the company is willing to go ahead with the issuance of securities. I think with this, I cover my part. I hope this has been useful to the audiences. What all we have already covered. We are there open to the Q&A at the end. But before that, Preeti, if you would like to give a brief intro about eMinds Legal.
Right, the most interesting part. While Chandan and I have tried our best, to educate or to add value on these provisions to the audiences. Just a quick brief about who we are. We are eMinds Legal. We call ourselves a boutique law firm. We are based out of Gurgaon, Haryana, and so we are a team of 50 plus professionals comprising of chartered accountants, company secretaries, lawyers, and CMAs also. Company secretaries being the largest vertical. We specialize in governance, risk, and compliance, and we serve 300 plus, I think now 350 plus clients pan India. So area wise, there's no restriction now. We are a team of 5 partners. Chartered accountants, CMAs, company secretaries, and lawyers, and basically divided into 3 verticals: corporate secretarial and FEMA, corporate legal, accounting, taxation, and payroll. We also take care of Posh compliances also for our clients. We've also, we are also proud to have authored an excellent book on companies that called Corporate Law Referencer, which is running its 10th edition now. And Chandan moved to the clients that we were serving. Chandan, could you please share some of the prestigious clients we've been serving? The clients such as Walmart, Fujitsu, Hitachi, Mitsubishi, Beer Cafe, Admiral Group, Actis, SmartWorks, Genpact, so Honda. So these are few of our prestigious clients, and not just the big multinationals, but we serve the startups. The advisory goes to the startups, SMEs, basically all categories, all functions. So we are there to help you in all your corporate legal, corporate secretarial, and compliance requirements.
Okay, so Chandan, you can. Okay, this was the slide for partners. Okay, so I'm one of the founder partners of eMinds Legal. With Preeti just explained, my partner Kapil K. Sharma is also a founder partner. We're all CS lawyers with 25 plus years of experience. And then you have Preeti Pahwa, who's a speaker. Chandan Narayan is also a speaker as an associate partner, and Sandeep Tyagi, who's a cost and works accountant and leads the accounting and tax practice at eMinds Legal, which is a 50 plus people lawyer firm. Okay, so Chandan, you can unshare the screen now. And I promised you that there's a surprise at 1 p.m. and you can see 2 more sort of people, 1 face and 1 more face. Shreesh, are you there? Can you switch on your video?
Hi, Shreesh, you're on mute.
Okay.
Hi, hi Preeti, hi Sumit.
Yes.
Hi,
So,
Shirish.
So Shreesh, we did not announce what was this 1 p.m. event. This is of course a webinar going on, and both Preeti and Chandan have shared their valuable insights and a lot of FAQs, and some I see a lot of audience questions also in the Q&A box, which we will soon answer. But 10 minutes if we may take for this very special occasion at eMinds Legal. So Preeti just mentioned that we have this leading book on company law called Corporate Law Referencer, which he said is running in its 10th edition. So it's partially correct, partially wrong. The book was running in the 9th edition. It is expected to run in its 10th edition starting day after tomorrow. So this is the I take this opportunity as a book launch, for lack of a better forum. This is the first author copy that has been given to us by our esteemed publishers, represented by Shrish. The publisher is Oak Bridge Publishing, and this is the first author copy. And believe you me, we haven't seen this book. Even I haven't seen this book. It has been presented to me wrapped like this only. And I'm told the other copies are under printing and they will be in the market from 1st of June. So let me take this opportunity on behalf of all the authors. The authors, there are many authors in eMinds Legal. I am the lead author, of course. Preeti Pahwa is the author. Chandan Narang is the author. You see Swati Ajmera, also a principal associate with eMinds Legal with 12+ years of experience. Kapil Sharma, who's also a company secretary, corporate lawyer with 25 years of experience, my co-founder. And 30+ people, company secretaries at eMinds Legal. They're all they have contributed in some way or the other to this beautiful corporate law referencer, which is now expected to run, not expected, which will now run in its 10th edition. So let me do the honors. I wish you were here, but we don't have any, any chief guest here. But okay, so let me do the honors here. You all can unmute yourself, and this is the 10th edition of corporate law referencer. I'm not very good at, opening things, but here we have the book. Can you have a huge round of applause from everyone? And you can express your thing on the chat box. Yes, thank you for the congratulations. So it's a 2-volume book, as you can see, some 3,000 pages. Corporate law referencer has been into printing for since 2013, since the Companies Act 2013 came. Let me share my screen very quickly. I would like to share the cover more closely with you. So here you can see the cover, Corporate Law Referencer, presenting a 360-degree view of the Companies Act and LLP Act with section-wise arrangement of circulars, orders, rules, notifications, including procedures, FAQs, resolutions, adjudication orders, and precedents. And I'll give you a sneak peek into the book right now. But I was sharing that this book has been into print for the last 10 years. Actually, this is the 11th year since Companies Act 2013 came. And every financial year, every April or May, we have been revising the book, enhancing the book, etc. So this is updated till 1st of May. And let me share with you what all does it have, or the highlights of the book. Here it is. First is annual editions. So rest assured, every year this book will be updated around April or May. Section is the king. There are 470 sections in Companies Act, period. Everything else is below the section, be it the rules, the notifications, the circulars, the procedures, the resolutions, the judgments. The entire commentary is below that section, and that is one of the key USPs of this book. And quick references means procedures. There are 150+ procedures and compliances mentioned within the book. Quick reference tables, there are 22 tables in the book highlighting compliances by listed and unlisted companies. There are 800+ FAQs. Chandan shared some 10-15 FAQs. There are 800+ FAQs again below the relevant section, which is all the crux of the entire advisory done offered by eMinds Legal. There are 250+ judicial precedents on crucial issues which enhance the interpretation of law. 100+ resolutions, secretarial standards, listed company compliances, 50+ adjudication orders, and of course the LLP Act and amendments made by Mediation Act and everything. So this is the entire thing, and I would like to show you a very important one section here. Preeti, can you see section 42 screen?
Yes.
Yes. So this is the extract from the book. I'm just giving you a flavor. This is, for example, section 42, and you have the entire statutory law over here, and below the law, of course, the exemptions, then the applicable rules. So the rules have been cut out below the section only. So, for example, Rule 9 and Rule 9A, what Chandan and Preeti were talking about, from the company's prospectus and allotment rules. They have been cut out and placed under section 42 since they relate to allotment of shares, rule 9b. Then you have, you see, I'm just forwarding rule 14 on private placement, including the history, citations, everything. Then I'm just scrolling down very quickly. The intent is to give you a flavor. Then you can see applicable circular right from 14 to all the circulars 2019, 2023, all the circulars that were issued in section 42. Then you see quick referencer, which is the procedure. So to whom it is applicable, what are the applicable rules, the relevant referencing, the compliance actions and timelines, procedures in layman language, very, very detailed, methodical notes. This is all the procedure. Compliances for mandatory holding of shares in demat form, all that you saw today, right? And in much more detail, procedures, then applicable non-e-forms, applicable registers, penalties, additional compliances. You see the depth of the commentary, the board resolutions for issue of shares on private placement with some placeholders. Then, such detailed board resolutions, what we offer to our clients, have been all offered in the book as knowledge. Board resolution for entering into tripartite agreement for demat of securities with those depositories and participants, etc. Then FAQs. So you see what is the difference between preferential allotment or private placement, and you have an FAQ. A lot of case studies, FAQs on valuations, on subscriptions, on bank accounts, on GNL2, PAS3, etc., etc. These are all real life queries posed to us by our clients. Of course, they are white labeled. All that knowledge flows into the book, and I repeat, there are 800 plus FAQs in the book placed under the relevant section, just like you are able to see, whether it is mandatory for an unlisted company to offer its shares in a demat form, and proper details referencing things like depository, participant, ISIN, what is for in Preeti's presentation today, demat accounts, etc., etc. So I'm just scrolling down very, very quickly. There are a huge number of FAQs under section 42, it being a very important section. And you see there, I'm just scrolling down, there are some 33, 34 FAQs. Adjudication orders by ROC. You would have seen ROCs offer adjudication orders, penalties, etc. And a lot of learnings come that, okay, how is ROC interpreting certain provisions, etc. So certain important extracts from adjudication orders have been placed there. Judicial precedents. Again, we are not repeating the law merely. There are thousands and thousands of judgments by several courts, but we have picked up only those judgments by Supreme Court, High Court, NCLTs, NCLATs, which enhance the interpretation of a section, which is not merely repeating the interpretation, but is enhancing the interpretation, so that brevity is the essence of it. Simplicity is very, very important. And there also we are giving you a proper citation. All judicial precedents have, you see, SARA India so and so that you can refer it back on whichever platform you use for cases. And these are actual remarks from the judgment. You see, it's in quotes, so that it's quotable. The para numbers are mentioned here in the citation, so that you know which para are we talking about, etc., etc. So this was the brief about the book, and we have the pleasure of one is Swati Ajmera, who is also a project leader of the book, who managed and coordinated a good team of 15-20 people behind the book. I'll have Swati share a few words, and then final note by Shri Chandra, who is the founder of Oakbridge Publishing. So Swati, over to you.
Thank you, Sumit. Thank you. So it's actually extreme pleasure to work on this prestigious book since its first edition. And over these 10 years, we all have seen company law and practicing areas are becoming so complex with MCA V3 portal. And the eMinds vision of simplifying law, with this vision, we have pondered all our knowledge, all our learning, all our practice experiences in this book under one section. So you need not to flip on section by section. Everything is there, be it rules, be it circular, be it notification, be it the editorial content, the commentary, the FAQs, the resolutions. And every year, every edition, I think we have also evolved, like adding new things to the book. be it listed content, be it resolutions, be it FAQs. And in this edition, as Sumit presented, that we have also added the ROC education orders to important topics to give you an insight how the non-compliance is affecting the industry. So this book is definitely a piece of, something idle, or you may say that the study material when we practice. Go for this, have it. And I've always heard whosoever has used this book, they are always addicted to it. So a big kudos to all of us, and all the best for the readers. We welcome all the feedbacks, and all the best.
Thank you. So without wasting any time, Shrish, over to you. You've been behind this book right from its first edition, and this is running into its 10th edition. So would love to hear from you.
Sure. Thank you, Sumit. It's a very momentous occasion for us to see that the work that was started 10 years back has come to the 10th edition now. So from many perspectives, I feel quite emotional in our association with this book. We have seen a lot of change in these 10 years. I mean, apart from the company law change, I have seen a change of so-called my profession, from coming from a service setup to getting into an entrepreneurial venture. I have seen you becoming Dr. Sumit Pahwa from just being Sumit Pahwa. So there has been a lot of change. It's one of the very significant publications that we have the proud privilege to be associated with. As Sumit said, that it's been my good fortune that I have been associated right from the first edition, and I've seen the transition happening. This book was started as a small, thin book, a royal size. Now it's grown into a 2-volume. It can be also used as a weight training tool. It's now so heavy. So I mean, I have great feedback from the readers, from the users of this book. This book has come of ages in these 10 years. It has grown both in terms of volume and in terms of its acceptance. Every year we tend to add new customers to this book. And in my own experience, whenever I've spoken to people who use this book or have recently been associated with this book, they all feel very gaga about it. This is one of the books that we publish for which the book trade waits. And we get a lot of calls in the run-up to the publishing of this book, when we keep answering calls on when is it coming. So this is one of the most awaited books in the market, in the legal and compliance space. So in fact, many congratulations to the author and the team. Sumit, so well done, great work. Let's keep doing some good stuff like this, and let's take it to the next level. I don't need to speak about what it contains because Sumit has already done it. But people who speak to me about the book, they say that things like quick reference tables, every information packed under the same sections, etc., are very, very handy and helps them a lot. So I wish to see at least 15 more editions before I retire. So let's hope that we do the 25th edition 15 years from now, and by that time, through experience, not through education, I will also become a little bit of doctor of sorts, and then both of us will be rejoicing the journey of this great work for the last 25 years. So congratulations to you, Sumit, and to the entire team. Especially Swati, because Swati has been our point of contact. In fact, I have two of my colleagues. I'll quickly give them a peek into the seminar. This is Priyanka and that is Bhupendra. These are the people who front-end the publisher side for the book, and they have also been kind of associated over all the last few editions that at least Oakbridge has done. So that's all, Sumit. I won't take much time. As I said, a great moment, and 10th edition is a good milestone, is a big milestone, and we should just keep striving hard that we add more number of customers, more number of readers for this book, and we take it to the next level. So all the best. Well done.
Thank you, Shrish. One for the trust that you reposed in us. It's not easy, to repose trust in a first-time author, and you repose that trust, 10 years back, and you've been reposing that every year. I know there are investments that the publisher makes with the trust that they repose. So thank you very much for your trust. And again, I would also like to thank Priyanka and Bhupendra both, and Priyanka especially because yes, just like you, she's been associated with this book for the last for the last 10 editions, and I know she's also personally invested in this book. So thank you, Priyanka, and thank you, Shrish. One more thing which Shrish did not mention as a publisher, which he should have, but let me mention as an author that this book is available all over India on all the leading stores, on all the leading bookstores, booksellers, bookstores, etc., including Amazon. And by the way, we also put it on our own website, and we'll share the links with all of you post this webinar. So you can start ordering the book starting tomorrow. We'll give some inaugural discount for this webinar participants for your patient hearing and for being part of our celebrations today. So thank you, Shrish. And Swati, you may stay put. We'll continue with the FAQs in the webinar and then close the webinar. So thank you, Shrish.
Thanks, Sumit. All the best.
Bye.
Thanks, Preeti. Thanks, Swati. Thanks, Kapil.
Okay, so without wasting any more time, and thank you, audience, for being with us. It's very good to celebrate such small successes with a huge number of people. So okay, so now without wasting time, we'll start the Q&A. I'll as a moderator, I'll ask the questions. Request any of the speakers, Preeti, Chandan, and I'll also onboard Swati from this point onwards. Swati, if you feel you have a very quick answer on any of the questions, feel free to sort of add to this as a co-author of the book. Okay, so but requesting the speakers in the interest of time to keep the answers to one-liners so that the webinar can be wrapped up in time. First question I'll answer: will the recorded webinar be available on YouTube or for later reference? Yes, the webinar will be available. Just follow our channels. My team, COMPLINITY team, please post the links once more in the chat box, and subscribe to all our channels, I would say, and you will keep getting notifications on several resources published. Okay, whether demat rules apply to private company which is subsidiary of a public company? Sujata says that.
Yes.
Yes.
Understand. Can we transfer shares by physical way before September 2024?
Yes.
Yes.
Good. These one-word answers are quite good. And by the way, the readers, if you want, I mean, not that the speakers will not say more, but something which is very, very clear, they will answer yes or no. And if you want to know the why, etc., of course, the book will have all these FAQs and commentaries. That also you may refer. Okay. Now, Sudhit Mathur says whether demat provisions in articles is mandatory. Second, procedure for issue of duplicate share certificate in case shares are lost or misplaced.
So let me take this up. Whether demat provisions in AO is mandatory, it is recommended to have it. No, the law does not mandate this, but it is recommended because as of now, the articles would contain provisions relating to physical shares. It's important for you to now get this included, the provisions related to shares in dematerialized form. Procedure for issue duplicate share certificates, request letter from the shareholder along with an FIR, an affidavit. Then the board will approve the issuance of duplicate share certificates.
Right. Okay. Next is if there is an NBFC which falls under the category of a small company, but small companies are exempted in this notification, adding to it the definition of small company, a company which is registered so and so and so. So my question is whether NBFC will be considered as a small company or NBFC is a special act, so NBFC these provisions will apply.
Okay, I'll take this again. So NBFC is not governed by any special act. It is regulated by a special act. So it's not a special act company per se. It's a company formed under the Companies Act. And therefore, if it is small company, it will not be required to follow the requirements here. It will be considered as a small company then.
How Ashwini says how the demat of securities will be impacted for private companies who have issued shares long back and have not paid stamp duty, whether this needs to be regularized now?
Yes.
Yeah.
Yes.
Okay. If there is no issue, so just so that if I understand that question properly, so Ashwini was asking that if a private company had not paid stamp duty on the physical certificates and now they are dematerializing, they will have to again, not again, they will have to pay the stamp duty now fresh on demand, right?
Yes, they have to
Yes, it is
pay.
advisable to move the application, because once you get your share securities converted into demat, you need to cancel your share certificates. So how will you apply for the stamp duty for the previous months? So better you go ahead with that.
But if the stamp duty was duly paid on the certificate, then again the stamp duty, of course, does not need to be paid on the demat.
Exactly.
No.
Right. Okay. If there is no Swati Saxena, if there is no issuance or transfer in this year, still I have to get the conversion done before 30th September.
Yes. So the rule says that we have to convert the shares of the promoters, directors, KMPs from before 30th September, even though there were no transfer. So in future, if you will transfer an issue, then it has to be in demat form. So from 30th till 30th September, the company's liability is to convert the shares of promoters, KMP, and directors in demat form.
Understand. Akanksha says if you are not going to transfer or issue security, then in case obtaining ISIN would suffice the purpose.
Yes.
Right.
Because I think the law is clear. It says for issuance, you have to issue your securities in demat form, and you have to facilitate dematerialization of shares.
Understand. Shikhar says the companies which are either holding or subsidiary company will not be considered as small companies. Accordingly, they are also required to dematerialize their shares.
Yes, yes.
Yes.
If Nidhi says if a company is a subsidiary of a private company or trust, is it required to file PAS 6?
So if
It has obtained ISIN, so then the company is required to file PAS 6.
So to add on this, if your shares are in demat, not only ISIN, your shares are converted into demat as on that half year ended date, 30th September and then 31st March, then you have to file PAS 6.
Okay, Jitendra says, I think this is a very common query which I am also getting. Jitendra says, PAS 6 shall be filed for March 24, still we are not dematerialized.
Once
He's saying we have not dematerialized. So if shares are dematerialized, then we have to file for this year. So that's a view that so that's something where clarity is not there. However, we suggest that we should file this form, that today is the last date of this form. If your shares are in demat, not only ISIN, the shares are in demat.
Yeah, but if the shares are in demat, even though the last date to demat those shares was 30th September, still you file form.
recommended.
Yes.
It is
However, if the shares are not in demat today, you still have time to get it done, so PAS 6 is not required.
Right.
Okay, Taruni says, can you please clarify on whether reconciliation of share capital audit will also apply to a private company? Yes, I think that's what PAS 6
is that only. Yeah.
PAS 6 is that only, but there is one audit that for that listed company, the regulation is different.
Right. What are the other compliances apart from PAS 6 to be ensured dealing with depository and saving? I think for that you must refer the book. There are a huge lot of compliances, detailed compliances. So look at the book. It will give you a lot of answers. Priyanka says, is financial year 23, March 23, the first year to check criteria?
Yes.
Yes.
Dipanjan says, how do company with foreign shareholders? Is this applicable for small company with foreign shareholding company?
For small company, it is not applicable. For other companies, even having foreign shareholder, it is applicable.
Yeah, so Chandan, you were sharing some details on how foreign shareholders can obtain. So any comment on that?
See, the foreign shareholders, while opening demat accounts, they are directors and they are promoters, etc. The KYC for and of directors, KMPs, or the ultimate beneficial owners are also required. So at times the companies are not pretty comfortable sharing their details, their ID, address, etc. So that was a challenge while opening of demat account.
Yeah.
Priyanka says, if a company has holding subsidiary structure and subsidiary crosses a turnover limit, then holding company is also required to go with demat.
So there is no turnover in this, so that the applicabilities comes on from all the private companies other than small companies. So if it's a holding subsidiary, in any case, it is not a small company, so it's applicable.
The question was holding cannot be a small company even if it's below within the thresholds of small company.
Yes, yes.
Yes.
Holding will not be a small company.
Yes. It's not it's exemption to small company.
Okay.
Or proviso to small company, the correct word.
Ashwini says estimated cost involved in Demat of securities one-time electing. I think Chandan answered that in his presentation.
Has
So
been shared already.
you
Yeah.
can again look at the webinar Ashwini recording and you will get the slide on that. Given NSDL is taking 3 to 6 months time to process the application, is the timeline of 30th September expected to be increased? It's anybody's guess.
I think we should be doing our bit rather than waiting for an extension of time. So let's go ahead and file for ISINs. If NSDL, CDSL are taking time, it's on MCA to review this.
Yeah, and I must add that at eMinds Legal, Preeti, Chandan, Swati, and the entire team is working on ISIN creation for a lot of clients, Indian and multinationals. So if you want any professional help, please, or even any not other than that assistance or queries, please feel free to reach out to them.
So that depends on the your particular case also, Sumit, the criticality, etc. Very recently, we obtained ISIN in 15 days time
15
also. So
Okay.
depends.
Understand. Okay, is it mandatory to get ISIN before 30th September or to do DMAT as well? Is only ISIN or to do DMAT as well?
So ISIN is mandatory, then Demat of your directors, KMP, and promoters holding is mandatory.
That is
Rest,
mandatory, yeah, but that is mandatory in case you want to go for further issuance or buyback or any of the event. Otherwise, only ISIN is mandatory as a.
ISIN is mandatory, and in her question, she's saying that suppose we go ahead for an issue on 29th of September, nobody stops you from doing it, but the entire process, any which way is you're doing it on the last day. So avoid that if possible.
Yeah, means
But in that case also
anytime the transfer, in my opinion, anytime the new issue of shares or the transfer or buyback or such corporate actions they come, then you may not have the time of 1 month, 1.5 months to do these procedures.
Right.
So at least to be ready for that, so that whenever the corporate action comes, you can execute it seamlessly. Amita says, please confirm if an Indian company is wholly owned subsidiary is located outside India is required to demutualize its shares as well.
no.
No.
The law is applicable for Indian companies, not the companies incorporated outside India.
Perfect. Akanksha says, what if a foreign shareholder is not having a PAN card in India?
you have to apply.
You have to apply for it, yeah.
So PAN is mandatory for Demat. Holding of PAN is mandatory.
Aman says, does the shareholders need to submit share transfer forms as well together with the share certificates to the DP?
No.
Submit share certificates, not
It's a
transfer.
DRF form, right? Not the share transfer form.
Yeah.
Right. Suresh says, your slide says the shares have to be dematted if the paid up capital is more than 4 crores and turnover is more than 40 crores. But the circular issued by MCA says paid up capital is more than 4 crores or turnover is more than 40 crores. If the paid up capital is more than 4 crores but the turnover is less than 40 crores, is it still required to get the shares? I think it says small company, right?
Yes, the definition of small company.
The circular doesn't say 4 crore, 40 crore, but it does say small company.
Small company which is
So
less
small
than
companies are exempted, other than small companies have to apply. It's very simple. Shika, if the company has obtained the ISIN but facing difficulty in opening Demat account of the shareholder, will it be considered as a non-compliant by the company?
So until unless you are not.
Until you come out with any request for transfer or you're coming out with any further issue. Till that time, there is no non-compliance.
Yes.
Because the other things you can't do until those Demat accounts have been opened and shares have been dematerialized.
Yes.
Asta says how to open Demat account in case of a registered shareholder and beneficial ownership is with someone else.
So we have to open Demat account for both the shareholders. So even the nominee shareholder holding one share is required to convert the shares into Demat mode.
Does register member is required to be maintained in physical form?
No, it will be
It's the BenPos that gets given. So
Yeah.
BenPos serves as a register of members.
Does Demat of securities affect the right of transferability of shares as in private company? They are not freely transferable, and with Demat has no hold on that. That's a very good question. Good question. Yes, if somebody would like to answer.
Yeah, I think Chandan, you have already discussed.
I've mentioned about that. Private companies have a right to restrict the transfer. So these days, RTAs as their process is are at the back end asking for approval from the authorized signatories. However, there is no defined process. They have built it in their processes. So to avoid any misses around that, companies may go ahead with the freezing of their ISIN so that transfer does not happen without company approving the transfer. So company will have to first unfreeze or defreeze the account, the ISIN, and then only transfer can happen. This way, companies can restrict the transfers.
Welcome to COMPLINITY Technologies. COMPLINITY is India's leading governance, risk and compliance software helping companies To manage their compliance, contracts, litigation, legal updates, inter-financial controls and more, COMPLINITY is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose COMPLINITY every time. Join the most innovative and prestigious brands that use COMPLINITY. Automating your compliance management. Request a demo at complinity.com.
Right. So freezing is an important tool for private companies.
Yeah.
Nikita says, is it mandatory to deutilize shares before 30th September or getting ISIN or ISIN is mandatory? I think we've answered this question.
Yeah.
Already answered.
Vinay says, if a private company already has its shares in demat form, does it require to file PAS for the half year ended March 24? I think Swati again answered that it's a gray area, but the err on the side of caution and do file it, right, Swati?
Yes, yes, yes.
Yeah. Does article need to be revised relating to provisions of issuance of share certificates?
We have discussed this earlier, yes.
So it is
recommended.
recommended.
Is it compulsory to get the shares demutualized with NSDL and CDSL? Both?
Either of them.
Either of them. You can't have both, right? It can be either, it can't be both, right?
Can be both also. It can be both also. Yeah.
Right. So either or both. So if it is both, then half, if the shareholders have demat accounts with a depository participant, which is NSDL or CDSL, then you may have to go with both. So
Right.
then
Yes,
reconciliation
exactly.
would be NSDL plus CDSL plus physical, that will be the reconciliation.
Yeah.
Right. Okay. Ishwarya says there is a nominee shareholder which is foreign body corporate holding one share on behalf of the holding company. Under what category demat account to be opened for nominee shareholder and how it will be reflected in BENCOS?
So the account holding would be same, but this detail has to be submitted at the time of conversion of shares into demat.
That company is holding as a nominee.
Yes. Generally, it's mentioned on the share certificate which you will surrender.
So it mentions nominee of this shareholder. So demat account number is linked to that.
Right. Okay, so we are although overshooting the time, but there are still few questions left and many participants still attending the show. And I know that after this session, they will go and have their sumptuous lunch. So it is we standing between the lunch and the participants. But as you are so interested and as I can see in the huge numbers, we'll take 10 more minutes maximum and we'll wrap up shortly by 1:45. Are the speakers okay with that to answer a few more questions?
Yes, yes, we are.
All right. So consent is taken. Audience, please stay back. Speakers have consented. I'll also very quickly do a rapid fire. Maybe your question is next. So Jyoti says, if a company hold ISIN but there are two shareholders not converted in the share into demat, will that work?
Yes. Unless that corporate action thing happens again.
Right. For small company exemption, what does paid up capital mean? Paid up is equal to equity alone or paid up is equity plus preference?
Equity plus preference.
Avinash says if there are three private companies, one is holding and another two are subsidiary, and all the companies are small companies, then do they need to demutualize?
So small company, as we discussed, if it's a holding or another subsidiary, then it's not a small company.
Not a small company anymore. So 4 crore, 40 crore, let it be under that. But if it's a holding or a subsidiary of any company, then it no more remains a small company under the definition. So it will have to then come back. Great. In fact, Swati, some of the questions which we find interesting, you should and they are good questions. You should add it in the next edition of our book. Next year, corporate law referencer. Yes. Shika, for the purpose of obtaining ISIN, can we process the application without alteration of articles?
Yes, generally the ISIN applications are routed without this, and we are even getting approval without any alteration to it because the RTAs and the NSDL is not saying that. However, we recommend it because the article should empower the board to accept those things. That's why it is recommended. While ISIN creation, there is no issues in getting it done.
Right. Nitin says PAS 6 is to be filed where? Is it MC only, right? Isn't it? PAS 6.
Yes, PAS 6 is with ROC, MCA.
ROC, MCA, right. Mahalakshmi says, in how many days can we be able to complete the process if documents are already prepared? We assume she might be asking for ISIN.
For ISIN, it's like, if everything is given, it will take, 3 to 4 weeks time. unless you have any complications or any resubmissions from the authority.
That's the ideal timeline, but yeah, it may extend. However, if your documents are complete, you can try.
Yeah, Priyanka says, what is the impact of this rule on ESOP? Let me answer that. If ESOPs are only options, this rule is not applicable. If ESOP are exercised and they converted to shares, they are like any other normal shares, and this rule will apply. Okay. Anonymous, we are the Taiwanese company having Taiwanese companies as shareholders. Our share capital was 3.9 crores as on March 23, and in March 24 another 1.6 crore was increased. Till when do we have to dematerialize the shares? It's an interesting question. Preeti, would you like to answer?
The timelines are 18 months, and March 24, your capital, your capital has increased and you do no longer remain a small company. So timelines will start from 31st March 2024, 18 months time.
So September 25 is your deadline.
September 25, yes.
Yeah. Manish says small company has holding company as one of the shareholder, holding company as an ISIN. Is a small company also bound? So again, Swati has answered. If you are holding on a subsidiary of a small, still you are not, means of any company, you are not a small company. So things will apply. Sangamitra, whether a private company without any transactions by September 24 will be required to demutualize. We have answered this question. So if there are any corporate actions, then these will apply. OCDs are also needed to be in demat. Optionally convertible debentures.
Yes. All kinds of securities are required.
All securities. And by the way, I'm sure it was mentioned in the presentation that every security needs to have a separate ISIN. So just to reiterate, if it's CCPS or OCD or CCD or equity, or even if it's CCPS Series A, Series B, Chandan, if it is different series as in startups nowadays, so every series will be a different class, right?
Yes, every series is a different class. Within the same series also there are different classes as so far as ISIN is concerned, depending upon the maturity dates.
Right, perfect. Ankit says whether private company needs to take different ISINs for preference shares. So, yeah, we've just answered that. So every different security is different ISIN. Please present slide 6. There's okay, so this don't know what's that. Articles we've already covered. If there are joint shareholders, should we need to open demat accounts of shareholders in joint name? Yes. Yes.
Both has to sign their that demat application form.
Not only joint name, but in the same sequence, first holder, second holder.
Yes.
If a private company was subsidiary on and ceases to be a subsidiary as on date, then it was a subsidiary as on 31st March 23 and ceases to be subsidiary as on today, then will the demat provisions apply?
So if it was a subsidiary as on 31st September, anyways, it was not a small company, so the provisions shall apply.
No, so in a way, the question is that at that time it was not, but now it may be a small company. Let's assume that in the query. That as on 31st March 23, it was not a small company because it was a subsidiary. Today, it has ceased to be the subsidiary, but it may be a small company today. So will this apply or not? It's a good question.
This shall apply because you'll check the status as of 31st March 2023.
23, yeah. Unfortunately, the law says that, so generally it will apply. Fortunately or unfortunately, I mean, it is good only. Okay. Oh, Nagesh says, what is the cost of the book, both the volumes? Thank you, Nagesh, for asking this question. At least somebody is interested in the book. Oh no, there are more now questions on the book. So the name of the book is Corporate Law Referencer. I will again display it here or show it here. Corporate Law Referencer. It's the only name, which is trademarked also because it's a unique name. It has acquired distinctiveness over the last 10 years. Sold thousands and thousands of copies. To all the good readers like yours. It is available all over India with all the bookshops on Amazon, and we will also share links of our website where you can order this online with some special discount for this webinar. All right. So the answer is cost. Cost of the book publisher doesn't tell us properly. It is 4050, 4050 rupees only. But of course, you'll get some trade discounts normally, like we get when we buy the books. But it's a collector's edition. Believe you me, just like anybody who uses Times of India as a newspaper or Hindustan Times, we are addicted to those and we can't change it. If you start reading this book, the guarantee of the challenge is you can't move to any other book. That's the challenge. So take this challenge and let me know whether I'm right or not.
I just want to add, so the publisher is running an early bird offer as well, that they are offering this book. If we order today, tomorrow, it will be worth 3,000 rupees.
Right.
Rest, our prices will be released soon as well.
Perfect. So just Google this Corporate Law Referencer. You'll surely find it, or ask your booksellers or shops or whatever. I'm sure you'll find us somewhere. Priyanka says, will this rule ease the cap table status? Since everything is in process, is there any rule which says DP shares a cap table to the company? I didn't get the question properly, although. Question is not very clear, so we'll skip it for the timing. Priyanka, you can reach out to the speakers separately. Preeti, can you share the contact slide once more, for everyone to note the credentials in case someone wants to reach out to eMinds Legal for any queries or any professional assistance with regard to this topic. In the meantime, I'll continue. Vivek Sundaryal says, do we need to dematerialize mortgage debt certificate? Chandan?
Yeah, sorry, I went to that.
Mortgage debt certificate. What is that mortgage debt?
That certificate, so we need to check if that covers within the definition of security as per SCRA. If yes, then this will be required.
Company limited by guarantee, will they be covered by Rule 9B?
No, the shares are required to be in dematerialized form. If the company is only limited by guarantee, then it is not required.
Then there are no shares only. So,
yeah.
Right. And can we dematerialize lost share certificate? Yes, I think you have to first apply for a duplicate and then go for a demat.
Yes.
Can demat securities be pledged for obtaining a loan? The answer is yes.
Yes.
Do you have offices in Chennai? Srinivasan asks. No, eMinds doesn't have an office in Chennai, but they do have clients in Chennai. So, right now everything is virtual. So, do reach out to eMinds Legal. I'm sure they'll give you good services in Chennai also. Foreign company and foreign individual need to have a bank account in India for demat of shares?
Not necessarily. If you go with the a DP which is a bank, they will ask you to open a bank account. Otherwise, DPs like SHCIL and Orbis etc., which I referred in my slides also, they don't require your bank account in India.
Chandan, I think the user, if want to ask, they need to have a mandatory bank account for a foreign shareholder. So that foreign shareholder need to have a bank account either in India or in their native country.
Yeah, it's not mandatory to have a bank account in India, but it needs to have a bank account.
So if they do not have account in India, the DP they might ask for a additional declaration and details of the account held in out of the India, whatever their location is.
Right. Okay, so Krishnan says, please incorporate answers to the FAQs in the PPT to be shared. So what we can do, although the answers were told, or maybe shared by the speaker, there are a few more questions left still, and the questions are even increasing and keep on coming. And I see the participation also wonderful at 1:45 p.m., 15 minutes after the designated time. So what we can do to the audience is, if I may request eMinds Legal, Preeti, Chandan, Swati, and the other eMinds Legal team to prepare a document, covering the questions which have been answered today, also covering the questions which have not been answered, and also the answers to the questions, Chandan, which were there in your slides. If you can prepare a beautiful document, I'm sure it will help the audience today. It will help the industry overall. It will help the professionals, and it will come out to be a beautiful docket. So, and that can be uploaded on our sites, and that can be shared on social media. So, friends, do share all the social. Do link up with us, COMPLINITY. Do link up with COMPLINITY on any of the social media, any or all of the social media like Facebook, LinkedIn, YouTube, Instagram, etc. I would say at the bare minimum, YouTube and LinkedIn, they are serious mediums for us, where we upload all the recordings on YouTube and share the blogs and articles and links to those videos also on LinkedIn. And you can also subscribe to our email updates on the website complinity.com. Subscribe to Spotify if you would like to hear this in a podcast format when you are coming from Delhi to Gurgaon or wherever you are from in India. On your drive, you can also listen to this webinar if required. So with that, I think it is 1:45. It will be unfair for me to hold all of you for lunch and also the speakers. And thank you very much, if I may say so, to the speakers to start with, for having shared their knowledge and having answered all these questions. And thank you to all the audience for participating in great numbers and for asking so many questions, for being so engaged and involved in the whole webinar, and for sharing our great moment of the book launch of Corporate Law Referencer. We hope that you will also buy Corporate Law Referencer, be a brand ambassador of that. Also recommend 10 more friends about it. Again, it's not about the authors. Believe you me, authors get very less royalties. It is not about the royalty. It is about the pride in authoring a book, and it is about the knowledge that we are able to share with thousands and thousands of people through the book. That is what is the kick which we get in authoring the book. And thank you very much, and goodbye, and we'll see you in the next.
Thank you so much, Sumit. And I'll quickly take this opportunity to thank my team members. Chandan and I were anyways there, but we had the great support from Swati, Diksha, Sneha, Ankita, Suruchi, and all the.
Yeah.
Yeah, sorry, Chandan.
Divyansh, I was saying.
So a lot of people in the team. It's a 30 plus people team, secretarial team, and I think most of them have worked on the knowledge sharing on this webinar as well as on the CLR. So thank you, everybody. Thanks, COMPLINITY, for giving us this opportunity, and we really appreciate your time. Thank you so much.
And let me also mention, last but not the least, there are 10 plus lawyers in eMinds legal also, who have also, many of them have contributed in the book in the judicial precedents section, where 150 plus judgments have been put in by the legal team. So host of company secretaries, lawyers have sort of contributed their heart and sweat into the book. Over to the readers. Read the book, give us testimonials, give us feedback for the next edition. Until then, bye bye.
Thank you. Bye bye. Have a nice day. Bye.
Welcome to COMPLINITY Technologies. COMPLINITY is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. COMPLINITY is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose COMPLINITY every time. Join the most innovative and prestigious brands that use COMPLINITY. Automating your compliance management. Request a demo at complinity.com.